No law requires you to record pledge your private automobile. As will be made painfully evident here within, a private automobile is not required by any law, code or statute to be recorded. Any recording pledge of private automobile to any agency is strictly voluntary. Any recordation contract you or a dealership has done was a fraudulently conveyed act as the recording agency automobile dealer told you that you must record your private property. The voluntary pledge that was done without just compensation is usually done through fraud, deceit, coercion and withholding of facts, which can only be construed as fraud and unjust enrichment by agency as well as a willful malicious act to unjustly enrich the recording agency and its public servants. Eichmann, through fear, fraud or mistake, should in terms renounce or give upany natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation. The right to freedom being the gift of Almighty God, it is not in the power of man to alienate this gift and voluntarily become a slave. Samuel Adams, our great president. Men are endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness, and to secure, not grant or create, these rights, governments are instituted. That property which a man has honestly acquired he retains full control of, subject to these limitations. First, that he shall not use it to his neighbor's injury, and that does not mean that he must use it for his neighbor's benefit. Second, that if he devotes it to a public use, he gives to the public a right to control that use. And third, that whenever the public needs require, the public may take it upon payment of due compensation. Budd v. People of State of New York, 143 U.S. 517, 1892. There should be no arbitrary deprivation of life or liberty, or arbitrary spoliation of property. Police power, due process. Barber v. Connolly, 113 U.S. 27, 31, Yikyo v. Hopkins, 118 U.S. 356. But whenever the operation and effect of any general regulation is to extinguish or destroy that which by law of the land is the property of any person, so far as it has that effect, it is unconstitutional and void. Thus, a law is considered as being a deprivation of property within the meaning of this constitutional guarantee if it deprives an owner of one of its essential attributes, destroys its value, restricts or interrupts its common, necessary, or profitable use, hampers the owner in the application of it to the purposes of trade, or imposes conditions upon the right to hold or use it and thereby seriously impairs its value. Statute 167 Amur. 2d, Constitutional Law, Section 369. Justice Bandes eloquently affirmed his condemnation of abuses practiced by government officials, who were defendants, acting as government officials. In the case of Olmstead v. U.S. 277 U.S. 438, 48 S. Court 564, 575, 72 L. ed. 944, 1928, he declared, "No law requires you to record pledge your private automobile." Page 1 of 24. Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a law-breaker, it breeds contempt for law, it invites every man to become a law unto himself. It invites anarchy. To declare that, in the administration of the law, the end justifies the means would bring a terrible retribution. Against that pernicious doctrine, this court should resolutely set its face. The duty of the licensor DMV Commissioner. The information created and surrounding the stricti juris doctrine regarding a particular license which may, or may not, be represented by and revealed within the contents and control of a license agreement, but must be revealed upon demand, and failure to do so is concealment, a withholding of material facts, the inducing, contractual consideration known by those who have a duty and are bound to reveal. Dalkater v. Manufacturers and Traders Trust Co. DCNY 2F Sup 637, 641. Is an automobile always a vehicle or motor vehicle? Argument. Federal. Motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in transportation of passengers, passengers and property, or property and cargo. Used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. 18 U.S.C. 31. A carriage is peculiarly a family or household article. It contributes in a large degree to the health, convenience, comfort, and welfare of the householder or of the family. Arthur v. Morgan, 113 U.S. 495, 500, 5S Court 241, 243 SD. NY 1884. No law requires you to record pledge your private automobile, page 2 of 24. The Supreme Court, in Arthur v. Morgan, 112 U.S. 495, 5S Court 241, 28 L. ed. 825, held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Hillhouse v. United States, 152 F. 163, 164, 2nd CIR. 1907. A soldier's personal automobile is part of his household goods. U.S. v. Bomar, CA 5 Tex. 8 F. 3D 226, 235. 19A. Words and Phrases, Permanent Edition, West Pocket Part 94. IT is a jury question whether an automobile is a motor vehicle. United States v. Johnson, 718 F2D 1317, 1324, 5th CIR. 1983. State use determines classification. In determining whether or not a motor boat was included in the expression household effects, matter of Winburn's Wool, Supra, 139 Misc. 5, 247 NYS 592, stated the test to be whether the articles are or are not used in or by the household, or for the benefit or comfort of the family. In Ray Bloomingdale's estate, 142 NYS 2D 781, 785 1955. The use to which an item is put, rather than its physical characteristics, determine whether it should be classified as consumer goods, under UCC 9109, 1, or equipment, under UCC 9-109, 2. Grimes v. Massey Ferguson, Inc., 23 UCC Representative Serve 655, 355 Sa2D 338 Allah. 1978. Under UCC 9-109 there is a real distinction between goods purchased for personal use and those purchased for business use. The two are mutually exclusive and the principal use to which the property is put should be considered as determinative. James Talcott, Inc. v. G. 5 UCC Representative Serve 1028, 266 Cal. App.2D 384, 72 Cal. RPTR. 168, 1968. The classification of goods in UCC 9-109 are mutually exclusive. McFadden v. Mercantile Safe Deposit and Trust Co., 8 UCC Representative Serve 766, 260 MD 601, 273A 2D 198, 1971. The classification of goods, under UCC 9-109 is a question of fact. Morgan County Feeders, Inc. v. McCormick, 18 UCC Representative Serve 2D 632, 836 P2D 1051, Colo App. 1992. The definition of goods includes an automobile. Henson v. Government Employees Finance and Industrial Loan Corp. 15 UCC Representative Serve 1137, 257 ARC 273, 516 SW2D1 1974. Household goods. The term "household goods" includes everything about the house that is usually held and enjoyed therewith and that tends to the comfort and accommodation of the household. Lowell v. Lowell, 515 P2D 900, 903, 21 Aries. App. 75 inches. 19A Words and Phrases, Permanent Edition, West Pocket Part 94. Cites Mitchell's will below. No law requires you to record pledge your private automobile, page 3 of 24. Bequest of such "household goods and effects" included not only household furniture, but everything else in the house that is usually held and used by the occupants of a house to lead to the comfort and accommodation of the household. State ex rel. Muller v. Probate Court of Ramsey County, 32 NW2D 863, 867, 226 Min. 346. 19A Words and Phrases, Permanent Edition, West, 514. All household goods owned by the user thereof and used solely for non-commercial purposes shall be exempt from taxation, and such person entitled to such exemption shall not be required to take any affirmative action to receive the benefit from such exemption. Aries. Const. Art. 9. 2. Automobiles classified as vehicles. H. Household goods. Did not include an automobile used by the testator, who was a practicing physician, in going from his residence to his office and vice versa, and in making visits to his patients. Mathis v. Causey, et al., 159 SE. 240, GA 1931. Debtors could not avoid lien on motor vehicle, as motor vehicles are not household goods, within the meaning of Bankruptcy Code lien avoidance provision. In Ray Martinez, BKRTCY, NM, 22 BR. 7, 8. 19A Words and Phrases, Permanent Edition, West Pocket Part 94. Automobiles not classified as vehicles. Automobile purchased for the purpose of transporting buyer to and from his place of employment was consumer goods, as defined in UCC 9-109. Malicote v. Volunteer Finance and Loan Corp. 3 UCC Representative Serv 1035, 415 SW2D 347-10. App. 1966. The provisions of UCC 2-316 of the Maryland UCC do not apply to sales of consumer goods, a term which includes automobiles, whether new or used, that are bought primarily for personal, family, or household use. Maryland Independent Automobile Dealers ASOC, Inc. v. Administrator, Motor Vehicle Admin. 25 UCC Representative Serv 699, 394 A2D 820. 41 MD App 7, 1978. An automobile was part of testatrix, household goods, within codicil. In Ray Mitchell's will, 38 NYS 2D 673, 674, 675 1942. 19A Words and Phrases, Permanent Edition, West, 512. Cites Arthur v. Morgan, Supra. He expression personal effects, clearly includes an automobile. In Ray Burnside's will, 59 NYS 2D 829, 831 1945. Cites Hillhouse, Arthur, and Mitchell's will, Supra. A yacht and 6 automobiles were personal belongings, and household effects. In Ray Bloomingdale's estate, 142 NYS 2D 781, 782 1955. No law requires you to record pledge your private automobile, page 4 of 24. Conclusion. Is an automobile always a vehicle or motor vehicle? No, this is a question of fact that turns on the use to which the automobile in question is put, i.e., either personal or commercial. While the presumption of an automobile being a vehicle or motor vehicle is created by the owner of said automobile registering same with the state as a vehicle, this presumption may be overcome by an affirmative defense to the allegation of the automobile being a vehicle, bearing any evidence to the contrary indicating commercial use. No law requires you to record pledge your private automobile page 5 of 24. Use defines classification. Private automobile is not required to be registered by law. Commerce for profit are immune to registration fees. Required to be registered under this code. Passenger vehicles which are not used for the transportation of persons for hire, compensation o profit, and house cars, are not commercial vehicles. A vanpool vehicle is not a commercial vehicle. And N type of vehicle required to be registered and use tax, paid of which the tab is evidence of receipt of the tax. Bank of Boston vs. Jones, 4 UCC Rep. Serv. 1021, 236A2D 484, UCCPP 9-109.14. And reasonable classification, and does not involve any unconstitutional discrimination, although it does not apply to private vehicles, or those used the owner in his own business, and not for hire. Desser v. Wichita, 1915-96 Con. 820, Iowa Motor Vehicle Asso. v. Railroad Commerce. 75 ALR. 22. According to the means by which they are propelled. Ex parte Hoffert, 148 NW 20. And MPT such persons when the transportation is not on a commercial basis means that they must exempt them. State v. Johnson, 243 p. 1073, 6 CJS Section 94 page 581. SEPTED from chapter which reads, Automobile, fire engines and such self-propelling vehicles as are used neither for the conveyance of persons for here pleasure or business, nor for the transportation of freights, such as steam road roller traction engines are excepted from the provisions of this chapter. Say Y21, 1909, Albany, New York, pages 322 to 323 which reads, There is no requirement that the owner of a motor vehicle shall procure a license to run the same, nor is there any requirement that any other person shall do so, unless he proposes to become a chauffeur or a person conducting an automobile as an employee for hire or wages. Yours very truly, Edward R. O'Malley Adder. The California Motor Vehicle Code, Section 260, private cars, vans, etc. not in AA, commercial vehicle, is a vehicle of a type E, B, R, C. A vehicle not used for commercial activity as a consumer goods, it is OTA. It is held that a tax upon common carriers by motor vehicles is based upon A. By thus self-driven vehicles are classified according to the use to which they are put rather than. In view of this rule, a statutory provision that the supervising officials may, X0, E. New Jersey Motor Vehicle Code Chapter 3, Section 39, 3-1. Certain vehicles exceed E. SN. E. Annual Report of the Attorney General of the State of New York issued on July 9. General. No law requires you to record pledge your private automobile page 6 of 24. C. Lassie. Also laws of Wyoming 2002, Motor Vehicle Code, page 142, sect, privately owned buses. Chapter 20 ****, 58 NCAG. 1. It follows that those citizens not engaged in extraordinary use of the highway for profit or gain are likewise outside the jurisdiction of the Division of Motor Vehicles. Since a sale of personal property is not REC W, there may be a transfer of title to an automobile without complying with the registration statute which requires a transfer and delivery of a certificate of title. N.C. Law Review Volume 32 page 545, Carolina Discount Corp. v. Landis Motor Co., 190 N.C. 157. The following shall be CE conformance with the provisions of this article relating to manufacturers, dealers, or non-residents. 2. Any such vehicle which is driven or moved upon a highway o the purpose of crossing such highway from one property to another. ***** 20 to 51 1-2 Comment. Not driven or moved upon the highway for transporting persons or property for profit. Case note to North Carolina GS. 12 to 3. Statutory construction. The California Constitution in Article 1, Section 8 and states that no one be compelled to be a witness against himself, is in agreement with the Supreme Court ruling in Haynes v. U.S. 390 U.S. 85, 88 S. Court. 722, wherein the ruling was that to force anyone to register anything as communicatee and such communicative evidence is precluded by the Fifth Amendment. No stat passage on the highways, byways, nor waterways, transporting his vehicles and personal property for either recreation or business, but by being subject only to local regulation, i.e., safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Chicago Coach Company v. City of Chicago, 337 Ill. 200, 169 NE. 22. W.S. of New York 1901, Chapter 53, page 1316, Section 169A. Ion 31-5. 110. CRCW 5.24.010. Not engaged in for hire transportation or outside the jurisdiction of Division of Motor Vehicles Enforcement of N.C. G.S. Article 17, required to be evidenced by any written instrument in order to be valid. It has been held in North Carolina that, exempt from the requirements of registration and the artificate of Title 1, any such vehicle driven or moved upon the highway in NLY 4. Similar statements made in all other state constitutions, man give, e-government entity has the power to allow or deny. No law requires you to record, pledge your private automobile, page 7 of 24. Granted by your Maker, and restated by our founding fathers as our color of law known as a private code, secret, or a statute. To wit, be not EVI impairs the rights of others. In Ray Newman 1858, 9c. 502. Traveling is passing from place to place, act of performing juon. Right of transit through each state, with every species of property and paramount law, is secured by that instrument to each citizen, and does not depend upon uncertain and changeable ground of mere comedy. In Ray Archie 1858, 9c. 47. Traffic infractions AR 3. 39. First, it is well-established law that the POO purposes, and that their use for purposes of gain is special and extraordinary, which, generally at least, the legislature may prohibit or condition as it sees fit. Stevenson v. Renford, 287 U.S. 251, Patchard v. Banton, 264 U.S. 140, and cases cited, Frost and F. Trucking Co. v. Railroad Commission, 271 U.S. 592, Railroad Commission v. Intercity Forwarding Co., 57 SW 2D 290, Harlot Cooperative v. Tidewater Lines, 164A. 313. F. Congress has authorized its curtailment. Road, Kent v. Dulles, 35, U.S. 116, 127. The right to TRA. So much is conceded by the Solicitor General. In Anglo-Saxon law that right was emerging at least as early as Magna Carta. Kent v. Dulles, 357 U.S. 116, 125. The use of the HIG, the fundamental right to travel, is not a privilege, it's a gift. Unalienable and cannot be taken by any man, government-made law. As general rule, men have natural right to do anything which their inclinations may suggest, if it ill in itself, and in no way. RNEY. D. Traveler is person who travels. In Ray Archie 1858, 9c. 47. Y. Owned to Constitution of United States, and recognized by that. E. Not a crime. People v. Battle, 50 Cal. App. Step 1. Super, 123 Cal. RPTR, 636, 6. Highways of the state are public property, and their primary and preferred use is for private freedom to travel is, indeed, an important aspect of the citizen's liberty. We are first concerned with the extent, if any, to which 7. Vel is a part of the liberty, of which the citizen, and not be deprived without due process of law under the Fifth Amendment, way for the purpose of travel and transportation. No law requires you to record pledge your private automobile, page 8 of 24. Thompson v. Smith 154 SE 579. ETR. Course of his business or pleasure, though this right may be regulated in accordance with public interest and convenience. Chicago Coach Company v. City of Chicago, 337 IL. 200, 169 NE. 22, 206. Po when using the public highways for the transaction of their business with respect to common carriers using the public highways for the transaction of their business in the transportation of persons or property for hire. That rule is stated as follows by the Supreme Court of the United States. A citizen may have, under the 14th Amendment, the right to travel and transport his property upon them, the public highways, by auto vehicle, but he has no right to make the highways his place of business by using them as a common carrier for hire. Such use is a privilege which may be granted or withheld by the state in its discretion, without violating either the Due Process Clause or the Equal Protection Clause. Buck v. Kuykendall, 267 U.S. 307, 38a, L. R. 286, 69 L. ed. 623, 45 Sup. Court Rep. 324. T. Pro radically and obviously from that of one who makes the highway his plakoff business and uses it for private gain, in the running of a stage, coach or omnibus. The former is the usual and ordinary right of a citizen, a right common to all, while the latter is special, unusual and extraordinary. As to the former, the extent of legislative power is that of regulation, but as to the latter its power is broader. The right may be wholly denied, or it may be permitted to some and denied to others, because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all the authorities, is the public and individuals cannot rightfully be deprived. Chicago Motor Coach v. Chicago, 337 IL. 200, 169 NA 22, 66 ALR 834. Ligaire v. Chicago, 139 IL. 46, 28 NA 934. Boone v. Clark, 214 SW 607, 25A. Ure, 1st, Highways, Sec. 163. TTR not a mere privilege which a city may prohibit or permit at will, but a common right which he has under the right to life, liberty and the pursuit of happiness. Not a mere privilege but a common and fundamental right of which he right of the citizen to travel upon the public highways and to transport his property thereon, either by a carriage or automobile, is. Then the legislature has no power to deny to a citizen the right to travel upon the highway and transport his property in the ordinary. It is now universally recognized that the state does possess such power to impose such burdens and limitations upon private carriers. He right of a citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs. No law requires you to record pledge your private automobile, page 9 of 24. In Thompson v. Smith, Chief of Police, Supreme Court of Appeals of Virginia, 155 VA 367, 154 SE. 579, 71 ALR. 604. September 12, 1930 it states, Constitutional law. Citizen's right to travel upon public highways and transport his property thereon in ordinary course of life and business is common right. The right of a citizen so to do is that which he has under his right to enjoy life and liberty, to acquire property, and to pursue happiness and safety. Automobiles, highways. Citizen's right to travel upon public highways includes right to use usual conveyances of time, including horse-drawn carriage, or automobile, for ordinary purposes of life and business. Injunction.